are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 8, State of Florida versus Danny Harold Rolling. Rolling terrorized the college town of Gainesville, Florida over 4 days in August 1990 when he murdered Tracy Inez Paules, Sonja Larson, Manuel Taboada, Christa Hoyt, and Christina Powell. Rolling was convicted and sentenced to death in 1994 and was executed in 2006. We'll talk about the evidence linking Rolling to the Gainesville murders, his trial, appeals, and execution. But first, we'll look at the murders of Tom, Julie, and Sean Grissom in Shreveport, Louisiana, a murder Rolling confessed to shortly before his execution. And good afternoon, Kyle.
Good afternoon, Lisa. How are you?
Very well. It's the end of a rough week. We had Memorial Day. We had the 80th anniversary of D-Day.
Right, exactly.
And I watched Band of Brothers, which was a mini series on HBO, which is now Max. Excellent. And it was interesting seeing a lot of actors like Tom Hardy, Michael Cudlitz, Michael Fassbender, Damian Lewis, in these different roles than what I've seen him in before, what I've seen in him that they've done since. But it was a really great show. Richard Speight from Supernatural was in it. Scott Grimes, the voice of Steve Smith on American Dad.
Oh, wow.
It was a lot of
I remember Tom Hardy. I've never watched it, but they're D-Day still, it's just kind of hard, honestly, to wrap my head around it, to be totally honest. I mean, just to think about those, some were 16 and 17, but the those young kids, being in the front, basically knowing you're gonna, I don't know, it's remarkable. I worry today. I know it's get off my yard, but I'm not sure if we had a similar situation today, if we'd muster the same level of courage.
Possibly not. And it looks at Easy Company, which was part of the 101st Airborne Division, 506 Battalion. And it follows them from their training for paratrooper training in Georgia all the way through till the end of the war. And they actually were at the Eagle's Nest, which is what Hitler's Austrian retreat was called. But it was a very good, very well done series. But they took part in D-Day in Normandy. They took part in liberation in Holland, or efforts to liberate Holland. They took part in Bastogne, which was the Battle of the Bulge. And then later on, they liberated a work camp, concentration camp in Germany, in Bavaria, and then Austria. So it was enlightening. And I'll probably end up watching the Pacific this weekend, which was
I heard that one was
companion
really good as
series,
well.
which was also good. So, but that's enough of my TV watching for the for the day. All right, so we have two separate series of murders. Rolling was a serial killer. And what we're going to do is first we're going to talk about the Grissoms in Shreveport, Louisiana, and then we'll go to the Gainesville murders, which got more attention and for which Rolling deservedly paid the ultimate price. First, we have William Thomas Tom Grissom. He was born September 2nd, 1934 in Ramsey, which is in Fayette County, Illinois. His parents were Joe Harold Grissom, who died in 1998, and Agnes Virginia Trueblood Grissom, who died in 1994. He had two brothers, Charles and Joe, who each died in 2011 and 2024, respectively. And then a sister, Julia Madge Judy Grissom Beatty, who died in 1998. Now, there's possibility he has other siblings out there, but they haven't passed, and so they're not linked to him on Find a Grave. He was a supervisor with AT&T. He was married at one time to a woman named Joyce Burton. He had two children, Scott and Julianne, who also died with him. She was born in 1965. His cause of death was multiple stab wounds. Then his daughter, Julianne Grissom, was born April 24th, 1965 in Greenfield, which is in Hancock County, Indiana. Her parents were William Thomas Tom Grissom and Joyce Burton. She had a brother, Scott. She was a marketing major. She initially went to LSU Baton Rouge, but had just transferred to LSU Shreveport. She also worked in sales at Dillard's in Shreveport. She also died of multiple stab wounds. And then finally, we have Sean Thomas Grissom. He was born October 24th, 1981 in Shreveport, Caddo Parish, Louisiana. His father was Scott Grissom. I did not find anything identifying his mother. I regret that I could not find that information, but this kind of is a little bit early for the internet, and so you don't find a lot of information on these cases about the victims. He did have a brother, Zachary, and he was in third grade at Turner Elementary in Shreveport, Louisiana, and he died of a single stab wound. And apparently I'm missing some pages because I had a summary of the Grissom murders. There it is. Oh, okay, because we're not going to talk about Danny twice. We're just going to skip him right now. We don't care about him. He sucks. Yeah, I know. Tell us what you really think, huh, Lisa?
No, I was going to say this one. I actually have a memory of this one. So I grew up in an area that was reasonably close to Shreveport, and we were definitely in the Shreveport Arklatex Media Market, and I remember the news coverage because I was at home then. Probably, I won't say how old I was, but I was old enough to remember and watch the news, and so it's weird, and the murder and his home was very near where I have a bunch of family, and so very, very familiar with the area.
Okay.
I'm guessing she probably worked at South Park Mall, Dillard's, which is closed now, but back then that was the mall in Shreveport.
I believe that is where she worked. I did not put that association in there, but if I recall from my research, that was where she was working.
Yeah, because that was the mall back in the day. It's funny, not to chase a rabbit, but yeah, Shreveport is gentrified, and actually the older area where my grandparents lived is now a little more hoity-toity, and the old mall that was dying when I was a kid is now back and the cool place to go. It's funny.
Mm-hmm. So, all right. So these murders occurred on November 4th, 1989. The victims were Tom Grissom, who was 55, Julie Grissom, who was 24, and Sean Grissom, who was 8. The murders occurred in the Southern Hills neighborhood of Shreveport, Louisiana, which is located in Caddo Parish. Tom and his daughter Julie lived in the Southern Hills neighborhood. On Saturday, November 4th, 1989, Tom's grandson, Sean, was visiting his grandfather and aunt for the weekend. His father was wrapping up his honeymoon after his recent marriage, and Sean was due back at school on Monday, November 6, 1989. Investigators theorize that Tom was grilling steaks on the backyard grill, and he was the first person to encounter Rolling, who escorted him into the utility room, then attacked him. Tom had multiple wounds in his back and chest, and his body was found slumped against the back door, blocking the entrance to the utility room. Sean was the next victim. His body had a single deep stab wound to the back that penetrated through his chest wall, and he was found face down in the family room. He had been attacked while watching TV. Finally, Rolling attacked Julie. He'd watched her and followed her home, likely more than once. She was found upstairs, face up on the bed, nude and posed, with multiple stab wounds to the back. She had been raped. Rolling used vinegar to try to destroy evidence in and on her body. Because there were no signs of forced entry and little evidence of a struggle, police theorized that Julie was the intended target and that Tom and Sean were killed because they were in the way or to eliminate witnesses. Rolling lived about 10 minutes away from the Grissom home in the Sunset Acres neighborhood with his parents. He'd been paroled from a prison sentence in Mississippi in July 1988. He'd also served time in Georgia and Alabama for robberies. On November 4th, 1989, he'd been fired from yet another job because he'd missed 3 days of work. Rolling exploded in a fit of rage and threatened to kill the manager and cook. Rolling's downhill spiral would continue. In May 1990, he shot his father and fled Louisiana for Florida. The similarities in the murders in Shreveport and Gainesville led authorities to consider Rolling a suspect in the Grissom murders. His name was added to warrants, but the warrants were never served, and authorities did not seek to extradite him from Florida. The case was closed officially in March of 1994. In a letter
how did they make the connection between the
because
Florida
of the posing of the bodies.
God. So they were just, that's some pretty good police work, because
yeah,
Florida and Shreveport are not close.
Yeah, the posing of the bodies and Rolling's attempts to destroy evidence that didn't really destroy evidence. There was eventually a DNA link.
Got it. Well, and I guess they would have known he was from Shreveport.
Or not necessarily a DNA link, but a serology link. Because the man who attacked Julie and the man who attacked the victims in Florida was a type B secretor, which is actually pretty rare.
Yeah, very rare.
So, but I think they did eventually do DNA, which also confirmed the serology. In a letter to the AP in 2000, Rolling hinted at the existence of more victims when he declared that he'd killed one person for each year he'd been in prison, and implied that he'd been driven to criminality by years of abuse at the hands of his father and the prison system. This was a claim Rolling also made to fellow inmates and psychologists. Finally, in 2006, prior to his execution, Rolling confessed to the Grissom murders, confirming what investigators in Shreveport had long suspected. He'd seen Julie, followed her, and attacked her and her family. He also confirmed that Tom and Sean were killed because they were in the way. So that is the Grissom murders. It was, like I said, it was closed with the serology link in 1994. But officially, Rolling confessed finally in 2006. All right, so now we go to the murders in Gainesville, Florida. And I remember these. I was in New Orleans working in New Orleans. I think I was at an insurance firm at the time. But I remember talking about it. It was, crazy and all over the national media. So the first victim was actually Christa Powell. She was born November 30th, 1972 in Jacksonville, Duval County, Florida. Her father was Frank William Powell. I never found her mother's name. She had a brother, Michael Raymond Powell, who was born in 1965 and died in 1983, which is terrible for her family. And then she had sisters Karen, Barbara, Kim, and Nancy, and a second brother, Frank Jr. She was an architecture engineering student, and she was starting her freshman year at the University of Florida at Gainesville. She died from multiple stab wounds. Then Sonja Jane Larson, whose birthday was January 1st, 1972. She was from Deerfield Beach in Broward County, Florida. Her father was James Bernstead Larson, who died in 1996, and her mother was Ada Larson. She had a brother and sister, Jim and Beth. She was an education major. She was also starting her freshman year at the University of Florida at Gainesville. She had worked as a daycare worker at the First Baptist Church of Pompano Beach, Florida, and she also died from multiple stab wounds. The third victim was Christa Lee Hoyt. She was born November 20th, 1971 in Miami-Dade County, Florida. Her father was Ralph Gary Hoyt, who died in 2000. Her mother was Teresa Ann Willingham Guerin, she died in 2014. She also had a stepmother, Diana. Her sister was Sandra, or is Sandra. She was a chemistry honor student at the Santa Fe Community College in Gainesville. She was also working at the time as a records clerk at the Alachua County Sheriff's Office, and she hoped to be a crime scene investigator. She died also from multiple stab wounds. Victim number 4 was Manuel Ricardo Manny Taboada, and because his parents were Cuban immigrants, so the correct pronunciation, if I remember my Spanish correctly, is Taboada.
Sounds good to me.
So, because if he was Pacific Islander, it might be different.
Right.
So, and the Taboada is an unusual name in whatever culture you're from. He was born September 14th, 1966, so he is 2 years younger than I am. Or he was born 2 years after I was. We share the same birthday. His parents were Manuel Mario Taboada. Manuel died in 1984, just as Manny was graduating high school. And his mother is Gladys Taboada. He has a brother, Mario. I believe the oldest, he was the younger brother and Mario's older. He was interested in architecture and was studied at Miami-Dade Community College and then transferred to Santa Fe Community College, also in Gainesville. He worked as a bartender, and he also died from multiple stab wounds. And but for a severe wound in his chest, he might have ended Danny Rolling's reign of terror. If he had been able to get the better of Danny Rolling, but he wasn't able to because he had been stabbed in the chest first while he was sleeping. He might have ended Danny Rolling's reign of terror. But for Danny Rolling was a coward. I'm just going to come out with that right now. Tracy Inez Paules is the final victim. She was born October 4th, 1966, so her birthday is a day after my mother's, in Deerfield Beach, Broward County, Florida. Her parents were George and Ricky Paules. She had a sister, Lori. She was a political science major at the University of Florida, Gainesville. She was in her senior year or starting her senior year, and she wanted to go to law school. She also died from multiple stab wounds. Okay, the perpetrator in all these cases was Daniel Harold Rolling. He's named Daniel in some sources and Danny in others. He was born May 26, 1954 in Shreveport, Caddo Parish, Louisiana. His parents were James Harold Rolling, who was born in 1932, died in 2012, and Claudia Beatrice Wilkinson Rolling, who died in 1995. She may have been born in 1933, not 1932. They were married when Claudia was 19. James Harold Rowling was a World War II veteran, and he was a police officer in Shreveport. Rowling had a brother, Kevin, who was born August 15th, 1955. Rowling was a high school dropout. He married Amatha Ann Halco in 1974. They were divorced in 1977. And he has a daughter, Kylie Danielle, who was born around 1975. He had been in the U.S. Air Force. He received an honorable discharge due to his drug and alcohol abuse. That should not have been honorable. It should have been dishonorable, or a discharge other than honorable. He had
Was it actually honorable? So was he actually
yes,
honorable? Oh,
yes, it was, and that era, I believe that was in the early 1970s. I think because of the drug abuse, people coming back from Vietnam, addicted to drugs, and then not doing well, coming back from Vietnam. I think that during those times, they were just doing honorable and not. Later, I think they started doing other than honorable discharge, which meant you were having problems and they're letting you go, but you're not, you haven't done anything necessarily horribly wrong, but you have done wrong. And so we're not going to say you were good. But I think in that time and it was probably fairly early in his service history. So they did honorable discharge. Mistake.
Yeah.
Emotional, mental, he had been diagnosed with antisocial personality disorder, inferiority complex, aggressive tendencies, poor impulse control, drug and alcohol abuse, and he was a peeping Tom rapist. His prior crimes included an armed robbery conviction in Mississippi in 1976, 2 counts of armed robbery in 1979, conviction in Georgia, a 1980 robbery conviction in Alabama. He had attempted robbery with a firearm, 3 counts in 1991 in Florida, aggravated assault on a law enforcement officer, 2 counts in 1991 in Florida, armed bank robbery, 1992 federal conviction, domestic violence against Amatha and other significant others, drug possession, rape, sexual assault, and sexual battery. He also was peeping and stalking because he would see victims and follow them and then attack them, rape them, and in this case, in Gainesville, kill them. So the victims were Christa Powell, 17, Sonja Larson, 18, Christa Hoyt, 19, Manuel Taboada, 23, and Tracy Paules, 23. The crimes occurred over 4 days. The first was August 24th, 1990. He attacked Christa Powell and Sonja Larson. Then August 25th, 1990, Christa Hoyt, and finally August 27th, 1990, Manuel Taboada and Tracy Paules. This all occurred in and around the University of Florida in Gainesville, Florida. That was in Alachua County, Florida. Rowling fled Shreveport after shooting his father on May 18, 1990. He armed himself with a Marine K-bar knife prior to the murders of Tom, Julie, and Sean Grissom.
I'm sorry if I meant, was he considered for his dad's murder? Did they know he did it?
No, he didn't kill. His father didn't die.
Just shot him. That's right.
He shot him in the face.
He died in 2012. My bad.
He died in 2012. Yep. He just shot him in the face. I'm going to say this. His father was abusive to Claudia, to Danny, to Kevin. But Danny also had some serious personality disorders going on. And while that can be exacerbated by the abuse, I think still it was an underlying flaw in his character and his personality that he would have had regardless of the abuse, of the level of abuse. I think a lot of the abuse is exaggerated to try to gain sympathy.
Yeah.
Spoiler alert.
Well, it is
Because
hard. I mean,
Kevin didn't turn into this monster that
it
Danny
is.
became.
Yeah, I mean, I personally struggle with that because you kind of feel like you need to take people's claims seriously, but also recognize it's pretty easy to claim abuse. I mean, I hate
And
to say joking, but I mean, it's like, is there a Hollywood star out there that doesn't claim that they were somehow abused? I mean, it feels like it's almost
yeah.
overcorrected where almost everybody says they have some kind of abuse.
And I've got to wonder with especially with Danny, how much was it bad behavior to try to make his dad look bad? His father's a police officer. How much of the abuse came from James's experiences in World War II and being a police officer? And, you know, he didn't want kids, and Claudia gets pregnant. And he didn't want kids. So how much of it stems from that? How much of it stems from, you know, like I said, Danny doing bad behavior to get attention? So it's kind of a vicious cycle. But Kevin went through this, grew up in the same household, and we don't see his name in the papers other than as brother of Danny Rolling.
Right.
So, and Rolling was an attention seeker, as we may or may not talk about a little later. So, on June 2nd, 1990, he broke into a home in Florida and stole 2 handguns and ID belonging to Michael Kennedy Jr., the homeowner's deceased son. After robbing the same grocery store twice, he took a bus to Sarasota, where he began using Michael Kennedy Jr.'s identity. On August 23rd, 1990, he arrived in Gainesville, where he set up camp in woods belonging to the University of Florida, which placed him near off-campus apartments rented by students. On August 24th, 1990, he entered the unlocked apartment of Sonja Larson and Christa Powell, who were set to start their freshman year at the university. He found Christy asleep downstairs, tied her up, then stabbed her to death. Sonja, who was still asleep upstairs, was next. He bound and raped her, then stabbed her to death. Rolling fled the apartment after mutilating Christy and Sonja's bodies and trying to destroy evidence using dish soap. Their bodies were discovered on Sunday, August 26th, when Christy's parents reported that she wasn't answering the phone or her door. On August 25th, 1990, he broke into Christa's apartment while she worked her shift at the Alachua County Sheriff's Office. When he found she wasn't home, he waited for her. When she entered the apartment at around 11 a.m., Rolling overpowered her, raped her, and stabbed her to death. Next, he mutilated her body, posing it and leaving a grisly scene behind. On the night of August 26th, when Christa didn't report for her shift at the sheriff's office, coworkers found her mutilated body in her apartment. And this was like a nightmare scene. If you've watched any of the true crime documentaries about Rolling, her coworkers at Alachua County Sheriff's Office have never gotten over what they found in her apartment. I mean, all of these murder scenes were gruesome and horrible, and Rolling was a sick bastard who did horrible things to the bodies, including violating them after they were dead. So he was into necrophilia, which I debated adding into this, but I'm just going to say it now. So he was a sick MFer, and he was a monster. He didn't like people seeing him as a monster, but he was a monster. On August 27th, he broke into the apartment shared by Tracy and Manny. He stabbed Manny in the chest, only to have him wake up and fight. After a prolonged struggle with Rolling, Manny died as a result of multiple stab wounds. And Manny fought hard. He was a big guy, 6'2", over 200 pounds, football player. I mean, if Rolling had not been able to catch him while he was sleeping, I think Manny would have broken Rolling in two. but that's not how it worked out. Tracy had heard Manny fighting for his life, and after seeing Rolling in Manny's room, locked herself in her bedroom. Once Manny was dead, Rolling broke down the door and subdued Tracy and bound her hands. After raping her, he stabbed her 3 times in the back. Likely fearing the noise of the struggle had drawn attention to the apartment, Rolling fled without mutilating Tracy's body. Edward Lewis Humphrey, a local drug addict and former resident of Tracy and Manny's apartment complex, was the initial suspect. He'd been arrested after attacking his grandmother, and neighbors reported that he had a crush on Tracy. He remained in jail for the attack, but was never formally charged with the murders. Rolling's days in Gainesville were coming to an end. He'd robbed a bank on August 25th, 1990, and was nearly caught by police, who discovered his campsite and seized everything there. The evidence seized would eventually link Rolling to the murders, but in late August of 1990, the Gainesville Task Force investigators had no idea that they'd encountered the killer. On September 8, 1990, Rolling, who'd fled to Ocala, tried to rob a Winn-Dixie grocery store. Police were called, and he fled in the car he'd stolen, leading to a car chase that ended with a crash and Rolling's arrest. So Rolling was initially arrested on September 8, 1990 for armed robbery in Ocala, which is in Marion County, Florida. On October 11, 1991, by this time, Rolling had been linked to the murders, and a grand jury was being impaneled to charge him. His counsel attempted to move the grand jury to another county due to the adverse publicity generated against Rolling. So this comes in later because they tried to challenge the competence of the counsel, because the trial was not moved from Alachua County, Florida. So I'm just showing you that, showing that his counsel was aware of the publicity in Alachua County, and they did try, but they weren't successful. He was indicted on November 16, 1991. The charges were 5 counts of murder in the first degree, 3 counts of sexual battery, and 3 counts of armed burglary of a dwelling with battery. The venue was the 8th Judicial Circuit, Alachua County, Florida. The docket number was 91-3832-CF-A. His counsel were Richard Parker, who is a public defender, Barbara Blount Powell, and John Kearns, at least in the pretrial phase. He pled not guilty on June 9, 1992. His attorneys, again, because of the publicity, filed on July 2nd, 1992, a motion to dismiss grand jury indictment, seeking to impanel a grand jury in another county to indict him. But unfortunately, Danny Rolling wanted to play games. He liked to play games. He wanted people to think he was crazy. And so on January 17, 1993, a fellow inmate named Bobby Lewis advised prison officials that Rolling desired to talk with task force investigators about the Gainesville murders. After verifying with Rolling directly that he wished to speak with law enforcement officers, task force investigators went to FSP to interview Rolling on the next day, January 18th. Now, before the interview, investigators made it clear to Rolling that they could not and would not meet Rolling's conditions for the interview, one of which was Lewis's release for his assistance in obtaining Rolling's statements about the crimes, and also reminded Rolling that he had invoked his right to counsel and his lawyer would not be happy if he spoke with them. At this point, discussions concerning the format for the interview itself broke down, and investigators did not talk with Rolling about the homicides on January 18th. Later on, they would complain that Rolling was somehow coerced into making incriminating statements to Lewis on that date. Go figure. He did actually give statements on January 31st and February 4th, 1993. They were made by Rolling to task force investigators. with Bobby Lewis serving as Rolling's mouthpiece. Rolling would then confirm that what Bobby Lewis was saying was accurate and true and correct. Rolling had also made incriminating statements to Lewis, who'd come forward to testify, hoping to gain some benefit out of the arrangement for himself, with complete approval from Rolling, who was still seeking Lewis's release from prison. So Rolling's playing games. And he's probably expecting that his attorneys are going to be able to get all these statements suppressed. But he signed waivers, and he in one of the statements on video is a waiver, kind of like them reading Miss Kelly his rights on one of his recorded statements in West Memphis.
Yeah.
And so people that say he wasn't read his rights are lying, because it's on the transcript of the statement itself that he was completely read his rights. Of course, then they say, but he didn't understand them. Well, which is it? It didn't happen, or he didn't understand it? Because it can't be both.
Yeah. No, exactly. Well, that's always the way in these things go, right? They change the standard depending on what side they're arguing on.
Yeah, and they move the goalposts.
Yeah, exactly.
So, in 1993, in April and May, Rolling's attorneys filed motions for individual voir dire of jurors, sequestered voir dire examination, meaning they would call jurors in one at a time, so that when they went into publicity and media coverage of the case, other jurors wouldn't be exposed to statements from jurors being interviewed. They also filed motion to sever counts of the indictment alleged to have occurred at each residence, and to conduct separate trials for the 3 days of murders. That was on May 7, 1993. A hearing was held on those motions on August 12th and August 13th, 1993. Rolling also filed on September 14, 1993, a motion to suppress physical evidence collected at his campsite, alleging that the articles were seized in violation of the Fourth Amendment of the United States Constitution and provisions of the Florida Constitution. On September 17th, 1993, the motion to sever counts was denied. Rolling amended his motion to suppress on October 4th, 1993. Hearings were held on the 28th and 29th of October, and on November 19th, 1993, the trial court denied his motion to suppress the physical evidence seized from the campsite. Then on October 29th, 1993, Rolling filed a motion to suppress statements made to law enforcement officers on the 31st of January and the 4th of February, 1993, alleging that those statements were obtained in violation of his Fifth and Sixth Amendment rights under the United States Constitution and analogous rights under the Florida Constitution. A hearing was held on November 15th through November 19th, and on December 30th, 1993, those motions to suppress were denied, or that motion to suppress were denied. The case went to trial. Counsel for the state was Rod Smith and James Nylon. Counsel for the accused were Richard Parker, Barbara Blount Powell, John Kearns, and John Fisher. On February 10th, 1994, because those motions to suppress and had been unsuccessful, and the challenges to the indictment had been unsuccessful, and the motions to sever had been unsuccessful, a petition to enter plea of guilty was prepared by Danny Rolling or his attorneys on February 10th, 1994. And on February 15th, the first day of the guilt-innocence phase, first phase of his trial, the petition to enter guilty plea was entered in open court, or filed in open court. On February 15th, 1994, Rolling entered his guilty plea, in which he acknowledged that he understood with his plea that he was subjecting himself to the maximum penalty possible of death by electrocution. He had not been subjected to any force, duress, threat, intimidation, or pressure to compel or induce him to enter his pleas, that no one had promised or suggested to him that he would receive a lighter sentence or probation or any form of leniency if he pled guilty. With the plea, he waived the right to direct appeal over the question of his guilt or innocence. The court would impanel, he understood that the court would impanel a jury to consider aggravating and mitigating circumstances and to make an advisory to the court regarding sentence, and that he was required to tell the truth and answer any questions asked of him regarding the offenses. The court found that based upon the testimony upon affirmation of the defendant, Danny Harold Rolling, in open court, the court finds that the defendant tendered pleas of guilty to each of the 11 counts of the indictment are freely, knowingly, and voluntarily entered by the defendant, and that there is a sufficient factual basis to support the pleas. But his counsel renewed their motions to sever for the penalty phase. That was denied. Jury selection began on February 16th.
What does that mean exactly, the sever? What does that mean specifically?
That means basically that instead of trying everything in a single trial, that they would hold a trial for Christy and Sonja, a trial for Christa, and a trial for Tracy and Manny.
Gotcha.
So that, because Rolling argued that each was a separate event and they weren't linked, but in reality they were. I mean, the MO in and of itself linked them.
All right.
So then during jury selection on February 25th, 1994, Rolling's counsel filed a motion for change of venue, which should have been filed before the trial began. That should have been among the initial motions to sever, motions to suppress. It should have been filed at the same time, but wasn't, because the attorneys representing Rolling at the time viewed Gainesville and Alachua County as a good venue to get leniency, because it was a college town, mostly college educated citizens, science-based people who were probably a little bit more on the liberal side, who might think because he pled guilty that he deserved leniency.
Got it. That makes sense.
But during their jury selection, a lot of jurors talked about how those 4 days, how scared they were and how the community was scared. And so then the attorneys thought, well, maybe this jury's not going to be lenient. But by then it was too late. A hearing was held, though, on the motion for change of venue, and it was denied from the bench with a formal written order pending. Rolling filed a supplemental motion for change of venue on March 17th, 1994, after the jury had been impaneled, with 9 articles published in the Gainesville Sun between December 31st, 1993 and February 25th, 1994, 14 articles published in the Independent Florida Alligator between January 4th and February 28th, 1994, and 11 articles published in the Florida Times-Union between January 1st and February 26th, 1994. Trial counsel also filed transcripts of 19 news broadcasts on WUFT-TV Channel 5, which aired between January 1st and February 28th, and 20 news broadcasts of WCJB-TV 20, which aired between January 6th and March 2nd. But I can tell you, there was probably no county in Florida that hadn't been exposed to media articles about Rolling. Saturated, right. I would say. Because I was reading about it in the Times-Picayune in New Orleans.
Yeah, it was a big story. I mean, I don't think you mentioned it. It was such a big story. It was actually, I think, apparently the inspiration for the Scream movie which has become a series now, but that
That's
was what,
although that's a claim that's been made, but Rowling stalked his victims, but he didn't contact them and
yeah, it may
talk to
have
them
been
the way
just
the
that,
character in the
yeah,
Scream. And if I recall correctly, in the Scream franchise, the killer is trying to get back at the victims for some perceived slight or for
yeah,
some wrong done to the killer by the victims.
I think that's right. Yeah,
They're
and it may
not
not
just
have been a
random.
direct story, but it may just been all the publicity around the
Yeah,
Gainesville Ripper made the director think, oh, what about a horror movie about a serial killer?
right. And I think there's one, at one point he claimed to have worn a mask at one of the crime scenes
Mm,
or one of the crimes, but you know, he was a liar. He was a monster. He was a sociopath. So, you know, he can make a lot of claims, but that doesn't make them true.
right.
And it could be possible, you know, that the calls to the victims could have been, but again, if I remember
Did you?
correctly, the killer in Scream had some, and these were random people. Rowling didn't know him. They didn't have shit to do with him.
Right.
They
Right.
were girls that he saw that he wanted to possess.
Right.
And that's it.
Did you know? Did we say? I don't remember what. I know why he left Shreveport, but do we know why he ended up in Gainesville? Did he have some connection there?
No. I think he just he had fucked up in Mississippi, Alabama, and
So
Georgia.
he just kind of kept making his
Florida was this
way.
next in
He just
line.
kept going east. Yeah, I
Yeah,
gotcha.
yeah. Florida was next in line. He went to Sarasota. He went to Tallahassee. I think he went to Tampa, either Tallahassee or Tampa or both. So he was kind of making the rounds in Florida, or at least Panhandle, North Florida. So I don't know where Gainesville is. So sorry, people, Florida people. I don't know my geography. I know Tallahassee and Tampa are kind of. Wait, no, Tampa's by Orlando, isn't it?
Tampa's on the Gulf side. I think
Okay.
Gainesville's on the I think it's on the I think it's a little on the east northeast. I don't know if it's on the water, but I do
Okay.
think it's the northeast.
Okay. He may have made it as far as Central Florida. So, all right. So anyway, the penalty phase, the judge had already denied the motion for change of venue. He
Oh no, never. I
probably,
apologize, Floridian listeners. No, Gainesville's like kind of in the it's north, but more in the middle of the state.
yeah, North Central.
Yeah, that's
Okay,
right.
cool. And Tallahassee, where's that?
That's in the I don't know, I guess the Panhandle. It's kind of
Okay.
north over in the Panhandle,
Okay. All right.
kind of halfway between the I guess Georgia border and the water. A little bit closer to the Georgia border, kind of north, but
And
not
then
near the
Tampa
water.
and Orlando are close, kind of. And they're kind of central.
Yeah, Orlando's kind of almost kind of in the middle.
Yeah. Okay. All right. Anyway, so the judge probably denied the supplemental motion. The penalty phase began on March 7th, 1994, and continued through March 24th, 1994. And basically, the state presented the underlying evidence of the crimes and proof of the aggravating factors. Rowling presented evidence and testimony regarding his mental health history, his family history of mental illness, abusive upbringing, and substance abuse. And you can see the opening statements on YouTube, the opening statement for the state, the opening statement for Rowling. And the whole thing for Rowling was just to try and get sympathy from the jury. Basically trying to say he was so damaged by his mental abuse and mental health, mental infirmities and abusive background that, you know, it made him a killer. The jury on March 24th, 1994, after I think 2 days of deliberations, voted 12-0 for death. And at the formal sentencing on April 20th, 1994, the court found 4 aggravating factors. Rolling was previously convicted of another capital felony or a felony involving the use or threat of violence, specifically that each of the murders were contemporaneous to the others, and Rolling had a series of violent prior felonies. The capital murders were committed while Rolling was engaged in the commission of sexual battery or burglary. The capital murders were cold, calculated, and premeditated without any pretense of moral or legal justification. And finally, the capital murders were especially heinous, atrocious, or cruel. And that was based on the fact that several of the victims had defensive wounds on their hands. We've got the struggle between Manny, and then I think Sonja Larson had defensive wounds. And the victims were stabbed multiple times, etc. The mitigating factors that the court found was that Rolling had an emotional age of 15, which was given slight weight, that Rolling had chronic antisocial personality disorder, which was given substantial weight. But again, as you know, antisocial personality disorder, borderline personality, that's a personality disorder. It's a flaw in your character. It's not a mental illness like schizophrenia that leads to a difficulty with reality and fantasy or knowing right from wrong. Antisocial personality, you know right from wrong. You just don't give a shit. And that was actually a when I was in high school, that was the description given by one of my psychology teachers. That was the best way he knew to describe it. You know right from wrong, but you don't care. You don't give a shit. You know it's wrong, but you're going to do it anyway because you want to do it. And you don't care what the consequences are, because a lot of the antisocial personalities are also very glib, and they're very charming, and they usually can talk their way out of trouble. And then he found 5 non-statutory mitigating factors, including dysfunctional family and that Rolling was physically and emotionally abused, which he gave significant weight to, and his background influenced his mental condition. Rolling's cooperation with law enforcement and that he confessed and pled guilty, which he gave moderate weight to, but again, he wasn't doing it out of the goodness or kindness of his heart. He was doing it because he thought he could get a benefit from it. He was doing it because he thought he could get leniency. Remorse existed to some degree, which I totally disagree with. I don't think there was an ounce of remorse in Danny Rolling's body. He was doing it. He wasn't sorry for what he did. He was sorry he got caught. And he was sorry that he couldn't talk his way out of trouble. And I think he also tried to play the nuttier than a fucking fruitcake card by claiming that the murderer was a personality named Gemini, and that he committed the murders, not Danny Rolling. And so, again, I don't think there was any remorse. He did give slight weight to the family history of mental illness, and he gave moderate weight to Rolling's mental condition or his capacity to conform his conduct to the requirements of the law. However, the judge went on to say he does not suffer from a psychosis. He is in touch with reality. He can appreciate the criminality of his conduct, of his actions. He knows the difference between right and wrong, and he does have the ability, impaired though it may be, to choose what's right and adhere to it. And then on May 20th, 1994, the judge issued a formal written order denying the motion for change of venue, finding that the court therefore found that the publicity, although pervasive, was not hostile so as to inflame the community in general, and further found that the pretrial publicity did not so prejudice prospective jurors that they could not evaluate impartially those factors which were to be evaluated in determining the penalty to be imposed in a capital case. Rowling was represented on direct appeal by David A. Davis, Paula Saunders, and Michael Wasserman. His case was decided by the Florida Supreme Court. The docket number was 83,638. The new style is SC 60-83,638. The notice of appeal was filed on May 4th, 1994, and the issues raised were, I'm not going to repeat the full. Basically, they challenged the failure to grant the change of venue by the trial court based on prejudicial, inflammatory, and pervasive publicity and the terror panic of the people of Gainesville and Alachua County, which was suffered in the weeks and months after the murders. The trial court erred in denying Rowling's motion to suppress the statements, as the statements were obtained in violation of his right to counsel. The trial court erred in denying his motion to suppress physical evidence seized from his tent. The trial court erred in denying Rowling's motion to sever and conduct 3 separate sentencing proceedings where the events at each residence were not causally linked to the events at the other residences and were interrupted by a significant period of respite. The trial court erred in finding the homicide of Sonja Larson was especially heinous, atrocious, and cruel because there was an allegation that she would have lost consciousness very quickly, and the trial court erred in giving an invalid and unconstitutional jury instruction on the heinous, atrocious, and cruel aggravating circumstance. Oral argument was held on August 29th, 1996. You can view that on the, no, you can't view that one. You can find that one on YouTube as well, I believe. On March 20th, 1997, a per curiam decision was rendered, and the court basically affirmed Rowling's conviction, finding that the trial court system of picking a jury was an effective one, which produced an impartial jury, that the evidence in the record and inference derived from supported the trial court's finding that the prosecutor's presence at the prison to render advice if needed during Rowling's statements did not violate the rules of professional conduct, and they affirmed the trial court's denial of the motions to suppress on that ground as well. They found the inventory of contents of the tote bag found at Rowling's campsite met the standards and was reasonable in light of the circumstances of the case, and they affirmed the denial of the motion to suppress physical evidence. Because the record and relevant case law support the trial court's finding that these murders were properly joined for penalty phase purposes, they rejected Rowling's severance claims. And because the evidence in the record demonstrated that Ms. Larson was awake but disabled by the duct tape over her mouth while she struggled with her attacker, sustained several defensive wounds to her arms and leg, and did not die instantaneously, they found that the trial court properly found the heinous, atrocious, or cruel aggravator proved beyond a reasonable doubt. And, it's interesting. I also think Manuel Taboada's struggle with Rowling and Tracy Paules seeing the struggle and trying to barricade herself in her room only to have the door broken down by Rowling all would qualify as heinous, atrocious, and cruel. Because the terror that Tracy Paules would have felt witnessing Manny struggling with his killer is, crazy for anybody to think that these murders weren't heinous, atrocious, and cruel. We reject Rowling's claim that trial counsel's and trial court's instruction of the jury on the HAC aggravator was unconstitutional. They found that the jury in Rowling's penalty phase trial received a specific instruction which fairly apprised the jurors of the definition of each term as well as the surrounding circumstances the state had to prove to support this aggravating factor. Finally, although not argued by Rolling on appeal, their review of the entire record in the case showed that death was the appropriate sentence for each of these brutal murders and is not disproportionate given in the facts and circumstances of this case. Accordingly, they affirmed the sentences. Again, he pled guilty. He had no direct appeal on the issues of guilt or innocence. Now, one judge concurred in part, but dissented that there is an obvious and substantial qualitative difference between the task facing the citizens of Gainesville compared to this case being tried anywhere else in Florida. While any community or group of potential jurors would have difficulty being objective in a case of this nature, the community actually violated has been affected in a way profoundly unique because of its relationship to the crimes and the victims. Sometimes we ask too much. I fear we have done so here. Rolling filed a motion for a hearing on April 3rd, 1997. That was denied. A revised opinion was issued on June 12th, 1997, but it's not clear whether the version that I had was the revised version or the initial version. So there may have been a slight difference between what was rendered on the 20th of March and what was revised on the 12th of June, but there's sometimes you find the March 20th and then the June 12th. And sometimes you only find one with both dates. And in this case, I found one with both dates. He filed a petition to the U.S. Supreme Court, which was assigned docket number 95-5975 on September 12th, 1997. That was denied on November 17, 1997. So his conviction and sentence became final on November 17, 1997. So his jury was a vote of 12-0 for death. The mandate from the Florida Supreme Court issued on November 24th, 1997, after the U.S. Supreme Court decision. And collateral counsel was appointed on September 21st, 1998. There were some parallel things that are not really covered or tangentially covered. Rolling had a lot of charges in Florida. You know, we've got the 1991 convictions, 1992 convictions. I didn't really go into all of those things because there's not a lot of firsthand information. There are some appellate decisions attached to those things, which I elected not to belabor. But there is one thing, is that at some point, Rolling hooked up with a woman by the name of Sonja Larson. She was going to write a book, and she was going to have memorabilia given to her by Rolling that she was going to sell to make money for herself and Rolling. They were engaged, apparently contemplating marriage.
That's so weird. That should be a whole episode. We should do an entire episode on women who marry killers in prison.
And she became a celebrity in her own right because she did write a book. She wrote several books about Florida death row inmates, including Rolling. I think I did read her book, and it just showed me what a piece of absolute shit Rolling was, because he was doing this to get famous. To be famous, to make money, to be rich, to live the high life, even if it was on death row. And so at some point, the Florida had a Son of Sam-esque law, and the state of Florida basically got an order against Rolling and London, basically putting a lien against any funds that they would collected by London on behalf of Rolling for story, artwork, songs, whatever. And they challenged that with the appellate court. There was initial appeal that was successful because he hadn't been convicted yet. But now in 1999, the lien was affirmed because he had been convicted of the crimes.
So, okay. Sorry, I'm going to give a rabbit hole warning. Are
Okay.
those laws just, I guess they're not in every state. And are they just while someone is incarcerated? I'm thinking about folks like, the Robin Hood Hills killers who are convicted, but then clearly have made money off the crime. And we don't have to spend an hour diving into it, but is it just that it's not in all 50 states?
Correct.
Okay, got it. So it's just
It's individual states had New York, I think, was the first to enact one.
Yep.
Florida enacted one. And this is an interesting topic that we may cover at some point in time. New York, I think their Son of Sam law was actually struck down and the
I think
legislature
that's
repealed it.
right.
But it was basically to prevent David Berkowitz
Yep. The
from
Son of
making
Sam
money on the
yep.
Son of Sam murders. In states where they have crafted versions that have been upheld, such as Florida, they've been pretty successful. And they've been pretty successful of preventing people from saying, well, this isn't my crime. This is me as a person. But, his artwork and his songs, you're infamous because you committed these murders.
Right.
Otherwise, nobody would give a shit about you. So whatever you're doing all derives back from your murder. So no, you can't make money. As it should be. I wish that there were a federal statute that would basically bring this into the federal realm. And it would apply in all 50 states. And it would even preempt state law, but there isn't. And enforcing it basically, sometimes it gives the victims, like in the Ron Goldman, Nicole Brown Simpson, they got a civil judgment against O.J. Simpson. So anytime he tried to make any money off the murders, they went in and they seized the proceeds, or they, got the rights to that money
right
out of OJ's hands. But that was part of enforcement of their judgment more than anything else.
I don't know if he ever really paid other than having to forfeit.
No, he left California and he went to Florida and made that his official residence so that they couldn't touch his pension. And then he basically just didn't do anything as an actor or as a spokesperson, because then they would have gotten the rights. They would have gotten that money. So he just lived off his pension. But I think the thing in Nevada, I think he was trying to get under the radar and make money from memorabilia.
Yeah, I think that's right. Yeah.
Was going to circumvent the judgment. And what happened was, because he was trying to do that, the person that he was trying to use to do it decided, well, I'm not going to pay him. And that's why he went and terrorized that person and kidnapped that person and held at gunpoint to get his stuff back. And he thought he had a right to do that because he was a bully and a monster and a sociopath. So, but maybe now that he's dead, we'll look at OJ, because it won't make me quite as angry to look at OJ's case if he's now that he's dead, and hopefully roasting. So anyway, Rowling went on to state post-conviction his counsel was Bia Harrison III. It was kind of, Florida's a hybrid sort of. You pursue in the trial court, but there are some things that you have to pursue before the Florida Supreme Court or the appellate court. He filed a motion to vacate his judgments and sentences pursuant to Florida Rules of Criminal Procedure 3.850 and 3.851 on November 13th, 1998. That was before the trial court. He filed an amended motion on April 16th, 1999. The trial court held a Huff hearing on December 1st, 1999, which is basically held to determine if the defendant was entitled to an evidentiary hearing to develop his claims. That was successful. So there was an evidentiary hearing on July 11th, 12th, and 13th of 2000 in the trial court, which on March 5th, 2001 denied relief, stating that in essence, the plea is to grant relief because the defense attorneys did not foresee the jury prejudice they soon enough perceived, and because when they did, the trial team could not convince the court of the reality of a prejudiced jury. The reality being overlooked in this argument is the entire history of the voir dire and the events underlying it. Perhaps the jury simply believed, after a full consideration, that the aggravating circumstances were not outweighed by the mitigators presented on Rolling's behalf. This was appealed on March 6, 2001 to the appellate court, and the issues raised were that the trial court committed reversible error when it denied the defendant's post-conviction motion to vacate and set aside his death sentence based on the claim of ineffective assistance of trial counsel regarding venue. The sub-issues that trial court erred in not finding that defense counsel rendered constitutionally ineffective assistance within the context of Strickland versus Washington by not effectively preparing for and litigating a motion for change of venue from Alachua County, and that the trial court committed reversible error by not applying the proper legal standard to determine whether the defendant suffered prejudice as a result of defense counsel's deficient performance regarding venue. A proper application of the law would have mandated a finding of prejudice sufficient to require a new penalty phase trial. Oral argument was held on April 2nd, 2002. This is actually available at the Florida Supreme Court's website. Very interesting. These two oral arguments, especially in a case where he pled guilty, and so the guilt and innocence was not before the courts. The decision was rendered on June 27th, 2002. Collateral counsel, in essence, first sought to have the trial court and now seeks to have this court second-guess trial counsel's initial decision about whether Rolling had a better chance, however slim it may have been, with a jury in Alachua County than with a jury in another part of Florida. We declined to do so. Declining to second-guess counsel's considered decision about whether Provenzano stood a bet. Oh, sorry, that's from a case that they're citing. Although attorneys may differ as to venue strategy, we agree with the trial court's conclusion that the decision in this case has not been demonstrated to have fallen outside the wide range of reasonable professional assistance. And then this is the citations to other cases, which I'm not going to go into. Rolling's additional suggestion that trial counsel were deficient for failing to conduct a community survey or study to determine the need for a venue change and to demonstrate to the trial court the impact the murders had on the Gainesville community was also rejected by the trial court. Although Dr. Buchanan, Rolling's expert, acknowledged at the post-conviction evidentiary hearing that a community survey might have been helpful as a supplement, he testified that actual voir dire questioning was a far better data collection process, enabling the defense team to see eyeball to eyeball the potential jurors and hear the emotional tone of the response. Further, as noted by the trial court, defense counsel attempted to, on a number of occasions, to use questionnaires to gauge the feelings and beliefs of the potential jurors. Although generally prohibited by the trial court in written form, these questionnaires formed the backbone of the defense team's voir dire questioning. Lastly, the trial court in this case undertook a meticulous jury selection process in order to seat an impartial jury and having heard the responses of potential jury members, it is unlikely that the trial court would have given much weight to the type of community survey Rolling now contends was necessary. Simply put, Rolling has not demonstrated any basis for this court to reevaluate its previous rejection of his claim alleging presumptive and actual prejudice on the part of jurors. In light of the amount of pretrial publicity, presented at trial, appellate counsel's strenuous argument on direct appeal as to venue, and the court's thorough examination of the issue, we find Rolling has failed to establish prejudice. For the reasons stated above, we affirm the trial court's denial of post-conviction relief, and a judge concurred in the result only, but didn't say much about anything else. A motion for rehearing was filed on July 12, 2002, and an order denying rehearing was entered on August 23, 2002. Rolling then went to federal habeas court with Claude M. Taylor Jr. representing him. His claims were as to venue, the denial of a fair trial by impartial jurors, failure of the trial court to grant a venue change based on theories of presumed and actual prejudice, and ineffective assistance of trial counsel regarding the venue issue. Claim number 2 was denial of Rolling's Fifth Amendment right to be free from self-incrimination and Sixth Amendment right to counsel regarding his statements. Claim 3, violation of Rolling's Fourth Amendment right to be free from unreasonable search and seizure. And claim 4 was Florida's death penalty statute is unconstitutional as applied to the petitioner. On October 16, 2002, a response from the state of Florida was ordered to be filed within 45 days. A response was filed on December 2nd, 2002 by the state of Florida, which may have been after a single extension of time. A motion for appointment of counsel was filed by Rolling on August 12th, 2004. My apologies. The court granted Rolling IFP status, which is indigent status, and appointing Taylor to represent Rolling on August 18th. A second motion to appoint counsel was filed on February 14th, 2005. So this is already 3 years or almost 3 years into his federal habeas claim. Certainly doesn't seem to be rushing to me. By Rolling to amend the order appointing counsel, which was granted on February 18th. On July 1st, 2005, an order was issued denying relief. And it basically found that Rolling's veneer was not presumptively prejudiced against him, and thus no habeas relief was warranted on that ground. The court found insufficient evidence in the record to rebut the presumption of correctness applicable to the state court determinations, and ultimately concluded that Rolling's veneer was not actually prejudiced against him. Rolling failed to demonstrate that the state court's rejection of this claim relied on erroneous facts or applied law contrary to established United States Supreme Court precedents, or in a manner which was objectively unreasonable in light of such precedent. Therefore, habeas relief was not warranted on that ground. The fact that the defense team changed their minds after voir dire began does not render the initial decision not to move for a change of venue earlier unreasonable. They used their collective knowledge and experience, as well as the expertise of Dr. Buchanan, to make an informed decision on venue, and their decision falls within the range of reasonable professional assistance. There's no evidence suggesting that a motion for change of venue would have led to a different outcome for Rolling. As the trial court stated in its order denying post-conviction relief, any challenge to the integrity of the proceedings that occurred must be measured against the gravity of the offenses and the total absence of innocence or even the thought of innocence of Rolling in the minds of the advisory jury. That would occur no matter where this case was tried. There were a lot of, it was basically, they have denied relief. They found none of Rolling's grounds had any merit. I'm going to skip over this because I'm stumbling over my words as we already, and it's not going to get better, folks. So basically, his writ of habeas corpus was denied. None of his grounds had any merit. Judgment was entered on the same date, denying relief. Rolling filed for a motion for certificate of appealability on July 29, 2005, and filed a notice of appeal on the same date. A response to the motion for certificate of appealability was filed on August 1st by the state. On August 8th, an order granting COA on counts 1, 2, and 3 was entered, and Rolling went to the 11th Circuit Court of Appeals under docket number 05-14252. The record was lodged on December 1st, 2005, and on February 6, 2006, the 11th Circuit entered its opinion affirming the denial of relief. They found that they cannot say that the decision of the state court about the strategic choice of Rolling's attorneys was unreasonable. Based on years of experience in criminal defense, Rolling's attorneys believed the jury veneer in Alachua County was more willing to consider a recommendation of a life sentence than other venues in Florida. The attorneys also believed that the jury veneer in this medical community was more likely to consider favorably Rolling's evidence and mitigation regarding mental health problems. The decision of the Florida courts that this strategy was sound was not unreasonable. Rolling argues that if trial counsel had presented more evidence of publicity, the trial court would have granted the motion, but Rolling's argument fails on two grounds. First, Rolling has not established that the determination of the state court that counsel's performance fell within the wide range of reasonable professional assistance was unreasonable. The test for ineffectiveness is not whether counsel could have done more. Perfection is not required. The Florida courts reasonably concluded that Rolling's attorneys performed competently in moving for a change of venue based on their extensive filings related to pretrial publicity. Because again, we see that they challenged the grand jury. They tried to get the grand jury indictment thrown out and move the grand jury or have a new grand jury proceeding. So, they did try or address publicity early on, and then they reevaluated and thought maybe Alachua County is not a bad place. Rolling has not established prejudice from counsel's alleged failure to support the change of venue motion. To the contrary, the same judge provided at Rolling's trial and the 3.850 hearing. After hearing the evidence presented at the 3.850 hearing, the court stated, "It is difficult to fathom what else counsel could have done to make the jurist any more acutely aware of the circumstances of this case prior to jury selection." The statement of the state court belies the contention that but for counsel's unprofessional errors, the result of the proceeding would have been different. The determination that Rolling was not prejudiced by any errors of his trial counsel was not unreasonable. Rolling's petition fails on both elements of his ineffective assistance of counsel claim. Because remember, effective assistance counsel isn't saying, well, they should have done this or they should have done that. They also have to show, had those things been done, that Rolling would not have been convicted. He would have been sentenced to life in prison instead of death, etc. So it's two things. You can't say they did wrong, and in and of itself, that gets them a new trial. You have to say they did wrong, and had they done right, this is what would have happened.
Right. Because, I guess you could argue technically everybody that gets convicted has ineffective counsel.
But yeah, and that's sometimes the fact. I remember seeing early on in discussing West Memphis 3, the fact that they were convicted based on so little evidence, as supporters saw it, was argued as, they had to have been bad attorneys. But that's not all there is. And, again, it's not just what they could have done better, but that it would have been a different outcome. And that's why they have now begun, quote, refuting the state's evidence with, quote, new evidence, new scientific evidence, etc. Because that's been the one thing that's gotten effective assistance. that's been successful. So on February 13th, 2006, the mandate issued. The court issued a corrected mandate on March 13th, 2006. I don't know what the corrected mandate was because I couldn't find a printed copy of it. He filed a petition at the U.S. Supreme Court, which was assigned docket number 05-10877 on May 9th, 2006. The state filed a response brief on May 26, 2006, and on June 26, 2006, the writ was denied. Rolling's death warrant was signed by Governor Jeb Bush on September 22nd, 2006. Some places give it as September 28th. There's 27th. Not quite sure. Setting Rolling's execution for October 25th, 2006 at 6 p.m. Rolling tried subsequent state claims. He was represented by Bia Harrison and Claude Taylor. Again, he was proceeding in both the 8th Judicial Circuit and the Florida Supreme Court. The docket number in the 8th Judicial Circuit was 91-3837 CFA, or it should have been 3832. I think I had a typo. And 06-1966 in the Florida Supreme Court. An expedited briefing and filing schedule was entered by the Florida Supreme Court on September 27th. On September 28th, Rolling filed public record requests. And this is interesting. He filed a public record request seeking all documents pertaining to execution by lethal injection of the 16 persons subjected to the procedure from the medical examiner of the 8th Judicial Circuit. Now, the Rayford, I don't think, is in the 8th Judicial Circuit. So the medical examiner would be from whatever circuit Rayford is located in. So it's entirely possible that he was asking for records that the 8th Judicial Circuit did not possess. He also wanted serological samples and independent testing of blood samples from death row inmate Arthur Rutherford, who was scheduled for execution on October 18th, 2006, from the medical examiner of the 8th Judicial Circuit.
Is he filing all this himself, or is he having an
No,
attorney?
the attorneys are filing this.
And are they just pro bono, or are they just, I was fascinated by this. Do they just do it kind of to think that maybe they can get publicity? Seems like a lot of work.
He was represented, they may be with the public defender's office. He was also declared indigent by the federal court. So they could theoretically seek compensation from public defender and or federal court and be compensated for their work. And I'm not judging, there's nothing wrong with that. They also may be doing it pro bono because they oppose the death penalty. And the reason they're seeking the serological and the independent testing is they want to determine the amount of drugs in the executed person's system to try and argue that the initial drug that's supposed to render you unconscious is not present in sufficient quantities to do so. And that, so therefore, the inmate suffered during the execution. They also sought record regarding the specific practices and procedures for carrying out lethal injections and certain medical records for Rawling from the Department of Corrections. Objections were filed by the Department of Corrections and the medical examiner's office on September 29, 2006, but unfortunately, none of these documents were online. So, as far as the trial court proceedings, the appellate court proceedings were online, but not the trial court. So I don't know. I'm framing the requests in what was cited in the appellate briefing.
Gotcha.
And so I don't know what the objections were. then he filed a successive post-conviction motion to vacate and set aside death sentences rendered on April 20th, 1994, on October 4th, 2006, seeking access to the files and records pertaining to Rolling's case in the possession of certain state agencies has been withheld, or claiming that access had been withheld. And that was in violation of Chapter 119, Florida statutes, and 8th and 14th Amendments of the United States Constitution, and Articles 1, 9, and 17 of the Florida Constitution. That the existing procedures that the state of Florida utilizes for lethal injection violate the 8th Amendment to the United States Constitution, as it constitutes cruel and unusual punishment. The administration of pancuronium bromide violates Rolling's First Amendment right to free speech, and newly discovered empirical evidence demonstrates that Rolling's conviction and sentence of death constitute cruel and unusual punishment in violation of the 8th and 14th Amendments to the United States Constitution. So this is, in essence, a lethal injection challenge. On the same date, October 4th, the trial court issued an order denying the public record requests, except that Rolling was provided with his own medical records from the Department of Corrections. And then on October 9th, the order denying successor motion to vacate sentences of death with special request for leave to amend was denied, finding Rolling's claims were all meritless. A notice of appeal was filed on October 9th, and the notice of appeal was amended on October 10th. The issues raised were to the lethal injection. Was Rolling entitled to a stay of execution in order to allow him the opportunity to challenge lethal injection as cruel and unusual punishment under the 8th Amendment? And did the trial court err in denying Rolling access to state records that he claims would support his 8th Amendment claim that lethal injection constitutes cruel and unusual punishment? And then issue 2 was, there's an ABA report that looked at Florida's death penalty scheme, and basically the ABA team has concluded, however, that the state of Florida fails to comply or is only in partial compliance with many of these recommendations, and that many of these shortcomings are substantial. So they want to use this ABA report to claim that Rolling's execution should be stayed, and his death sentence should be set aside in light of the ABA report, which is not, it's not a judicial finding. It's a group of anti-death penalty lawyers who say, well, Florida's not doing right by its death penalty. It's not doing things right. Everything's wrong with its system. And so we can't trust the system. And so we shouldn't execute anybody. But it's not a judicial finding that there's any flaw in the procedure or the process. And it's not new because it's based on studies that have been around for years. It's just, again, more BS by opponents of the death penalty to try and give the public the impression that there's something wrong. Right. The Florida Supreme Court rendered its decision on October 18, 2006. As to lethal injection, they found that in reviewing a trial court summary denial of post-conviction relief without an evidentiary hearing, this court must accept all allegations in the motion as true to the extent they are not conclusively rebutted by the record. To uphold the trial court's summary denial of claims in a 3.850 motion, the claims must be either facially invalid or conclusively refuted by the record. And that was based on a holding in Rutherford versus State, which was an identical challenge. They find no error by the trial court under this standard. As to cruel and unusual punishment, the trial court summarily denied this claim and found that Rolling was not entitled to an evidentiary hearing on whether lethal injection as administered in Florida constitutes cruel and unusual punishment, stating that this court determined in Sims that lethal injection as administered by the Department of Correction did not constitute cruel and unusual punishment. This court addressed the same claim now asserted by Rolling and upheld the trial court's summary denial of the claim. We again rejected such a claim in Rutherford versus State. As in those cases, we affirm the trial court's summary denial of this claim in Rolling's case. They also addressed the First Amendment claim. Basically, Rolling saying pancurium bromide, which is the paralytic, takes away his right to express the pain he's suffering, or his right of expression altogether. The circuit court summarily denied this claim. In Rutherford, the court addressed the same claim and found that because the defendant could not demonstrate that the chemicals involved in lethal injection would be administered improperly in his case, the defendant was not entitled to relief on this claim. Therefore, as in Rutherford, we find Rolling's identical First Amendment claim to be without merit and find no error in the trial court's denial applying our decision in Rutherford. They also denied the public records claim. And then finally, as to the ABA report, we recently addressed this issue in Rutherford, wherein we concluded that the ABA report is not newly discovered evidence because it is a compilation of previously available information related to Florida's death penalty system and consists of legal analysis and recommendations for reform, many of which are directed to the executive and legislative branches. We also held that nothing in the report would cause this court to recede from its past decisions upholding the facial constitutionality of the death penalty, and that the defendant did not allege how any of the conclusions in the report would render his individual death sentence unconstitutional. For these same reasons, we affirm the circuit court's summary denial of Rolling's claim. On October 19th, 2006, Rolling filed an all writs petition in the Florida Supreme Court, docket number SC-06-2041. This is not available online. I don't know why. I don't understand why. It is an extraordinary action, but I don't understand why, if they can put direct appeals and they can put post-conviction appeals up, why they can't put all writs up as well. This absolutely totally bites, because I've looked under several cases before and after Rolling where all writs was invoked. And this is basically the state Supreme Court. It's a writ of habeas corpus in the state Supreme Court. Now, I do know that this was another end run challenge against Florida's lethal injection, but I don't know specifically how or what. They did try to invoke again the Florida, the public denial of public records requests and the ABA reports, but I don't know, without seeing those petitions for myself, I don't know exactly what or how this was done, or what facts they relied upon. So I'm very frustrated. I'm sorry. And I will keep digging, and hopefully one of these days we'll find an all writs petition. That I was so aggravated. I found a blog that had the caption, and it had the case caption, it had the title all writs petition, and then it went to a completely different topic, and the link was dead. So I was very frustrated. On the 19th, the court issued its order. Danny Terrell Rolling, who is under a pending death warrant with his execution scheduled for October 25th, 2006, has filed a petition seeking to invoke the court's all writs jurisdiction. We recently addressed the same claim, now asserted by Rolling in Rutherford versus Christa, case numbers SC-06-2023, and denied relief. We find no basis for distinguishing our decision in Rutherford, and accordingly, Rolling's petition is hereby denied. No motion for rehearing will be allowed. It is so ordered. He filed an application for stay of execution at the U.S. Supreme Court under 06A 405 on October 23rd. He filed a petition for certiorari under 06-7284 on October 23rd as well. I don't know what it was. I guess it might have been a lethal injection challenge, or access to the records. of the Department of Corrections, but it's not available online, so I don't know for sure. And that was denied. Both stay of execution and the writ were denied on October 25th. So his death warrant was signed either the 22nd or the 27th, 28th by Governor Jeb Bush. His execution went forward on October 25th, 2006 at Florida State Prison, Rayford, which is in Union City, Florida. I don't know what county that is. I should have looked that up. The drugs were administered probably around 6:00 p.m. The bastard had the fucking nerve to sing a self-written hymn. He fancied himself a songwriter and he sucked. He sucked horribly. And he sang his own little hymn, hopefully thinking he was getting himself right with God, and that wasn't where he's going. And his death was declared at 6:13 p.m. And aftermath, I mean, this was so many victims. He had 8 victims. And they had families.
Did
they
he
had
apologize
friends.
to any of them?
No. Was he ever remorseful? Let me get up on my soapbox here. In my opinion, Rowling's antisocial personality disorder rules out any chance that he was ever remorseful, except perhaps for himself. Like most sociopaths, Rowling could play remorse. He could say the words, he could make people think he meant them, but in reality, his words and actions in the years between his arrest and execution proved that his guilty plea and his claims of remorse were nothing more than ploys he thought would earn him leniency from the court, the jury, or the public. Rowling was a con man at heart, but he was never smart enough to pull the cons off. That's why he failed so often. When he failed, he would play remorse and try to con people into believing that he had multiple personalities, with a bad guy taking over and making him commit crimes. He used Bobby Lewis to play games with investigators, likely expecting his attorney to succeed in suppressing those statements. His decision to plead guilty prior to the first phase of his criminal trial was more likely than not done in the belief that the jury would take that as remorse and sentence him to prison for life. The fact that Rowling saw the murders as some sort of payback for his years in prison is further evidence that he had no remorse. A normal person doesn't victimize innocent people for transgressions that have nothing to do with them. Only sociopaths do that because they lack empathy and the ability to care about others. They only care about themselves. Even at his execution, Rowling didn't apologize to the families of Tom, Julie, and Sean Grissom, Sonja Larson, Powell, Christa Hoyt, Manuel Taboada, or Tracy Paules. He didn't acknowledge the years of pain he'd inflicted on them, he didn't acknowledge the years of pain he'd inflicted on their family members, friends, and loved ones. He didn't even say their names or apologize to any of his many victims.
Yeah, I think that's super telling. I mean, I think it's interesting too, because the fact that he won't mention their names, I think says a ton. Yeah. And won't even apologize. I feel like that's the very least one could do in that situation.
Yeah. And I think, like Ted Bundy, I think the confession to the Grissom murders was an effort to try and stop the clock. That, okay, now Shreveport's going to want to talk to me. Maybe they're going to want to try me. So, they'll ask Florida not to execute me now. Similar to what Ted Bundy did. And, I think it was Bob Keppel who kind of took a little bit of joy in telling Bundy, well, no, we're not going to stop your execution. We're going to get as much as we can out of you now. And then it's bye-bye on January 24th.
Mm.
Because when they did that, Bundy shut the fuck up. So, but yeah, it's so many victims with just the family members and friends. I mean, Christy and Sonja had a roommate who just didn't happen to be there that night.
Yeah,
and this had an impact on her. I mean, if you Google Danny Rowling, a lot of what you get is about him, which just sucks big time. But sometimes you find these kernels. I mean, there was a a reporter, either with a media, print or visual media outlet, who was impacted 25 years later. There was I think 2020, just a year or so ago, did an episode about the Rowling case.
Yep.
And, people still, Sean's father and brother, his stepmother, or again, I didn't find who Sean's mother was. So I don't know if the woman that Sean married just prior to that his father Scott married just prior to Sean's death was Sean's mother or stepmother. So yeah, it's very, because it's possible that Scott and this woman were together for years, and they had Sean, and they had Zachary, and then they decided to get married after years of being together. So, but it's a very difficult case. And I remember it, and I remember just thinking what a waste it was for all these poor young people. But what always struck me most is when you look at what happened with Christa Hoyt, how horrific it was. And how horrible the crime scenes were for each one. That's stuff that these people still aren't over.
Mm-hmm.
The investigators, and the investigators for the Grissoms. I mean, Tom and Julie were hard, but Sean scarred the investigators for life, because this is a little 8-year-old boy, and it was horrific for him. So, and he and Tom were killed because they were in the way. And again, Rowling saying he killed one person for every year he was in prison, that proves what he was, the monster that he wanted us to believe he wasn't. Because he would write to AP and say, I'm not a monster. I'm not a troll living under a bridge. Yes, you are a monster. What you did to these people, because you felt like you had a right to do it, because you had a hard life, because your dad abused you. And I kind of, like I said, I wonder, was the abuse brought on by Rowling not behaving properly and doing things to get in trouble?
Right.
And he's an antisocial personality disorder. His dad's a cop. Of course he's going to do things that are going to make his dad look bad as a cop.
Right.
Or that his dad, or that he knows are going to push. Was he pushing his father's buttons part of the time?
Right, exactly. Well, and it's always hard too. Like, I mean, what is, define abuse? I mean, was it, being told no may not be abuse. Maybe he was abused, but it also could be he just didn't get his way.
Well, I mean, he had family members, but I wonder how much was exaggerated. He had family members that did corroborate some of the claims, and there was claim of abuse of his mother. But I wonder how much of it was exaggerated to make Rowling the victim, how much of it was out of context.
Yeah.
But James's experiences in World War I could have totally given him sort of a split personality, a Jekyll and Hyde personality, that when he's back in his head, and whether he served in the Pacific or Europe, he's back in combat, post-traumatic stress disorder. He's suffered post-traumatic stress disorder. It wasn't recognized at the time, but that's what he had. And that can be, I mean, people, especially with combat experiences, it's like they're not even here. They're not in the same time and place that you're in. and you have to pull them out. You have to pull them back because they go back to combat.
Right.
Wherever and whenever it was. There was one of the things with Band of Brothers is they had a follow-up show where they talked to the veterans one-on-one, but before each episode, the veterans recounted some of their experiences and the impacts that these events and experiences had on them. And there was one, I don't remember when it was or who it was, but they said one of the guys, when he went back home, he slept on the floor next to the bed. And when his wife asked him why he was doing that, he said, because if you accidentally touch me in my sleep, I'll kill you.
Mm.
He just knew that,
Yeah.
that's what would happen if something happened when she was asleep. And in the Band of Brothers, there was a guy who went up to a foxhole, was trying to wake up his relief, and the kid stabbed him with the bayonet, thinking he was a German, and that their position had been infiltrated. And then there was another guard or sentry who shot an officer who was walking with another officer along train tracks, and they identified themselves, but the sentry was just caught up and shot first, asked questions later, because they were near an enemy position,
Right.
And in a vulnerable place. So, like I said, I mean, James might have been a monster. He might have, that might have been where Danny got it from, but he may also have been shaped by his experiences and not entirely in control of himself 100% of the time. So anyway, well, that is, I think we're done.
No, an interesting but terrible case. Just the strange Shreveport connection, and then the potential Scream movie connection. Just very, very interesting, but
Yes.
terrible. I can't believe how horrible. I mean, it's hard to think about what a horrible monster he was. I mean, like you said, the killing is bad enough, but the brutality and the butchering is just, it's beyond the compare, even for a lot of serial killers.
Mm-hmm. Yeah. And, and I wonder if you've seen Rolling in court, when he was sentenced, he sang, he had interviews where he sang, he did interviews. I'm wondering if the victim saw that, whether he played that meek, mild, I'm not going to hurt you. He claims that he broke into a woman's house, and that, he got, she was so upset and he felt bad. And so he ended up just talking to her, and then they had consensual sex. But I think he broke in, he scared the shit out of her, he raped her, and then he left, and he told himself it was consensual.
Mm-hmm.
Yeah. But yeah, he was a monster. But I wonder if he tried to play sociopath that he is. He tried to calm their terror and then, amp it up.
Yeah, I'm sure.
So, and whether he made false promises of not hurting them if they gave him what he wanted. And as we know, rape isn't about sex, it's about power.
Right.
So, all right, well, that is another one in the books.
Well, thank you for all your work, and have a wonderful week. Hopefully next week is not as crazy as this week was.
Yeah, your mouth to God's ears. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'Brien LN. Kyle and I will return in 2 weeks for episode 9, The Failure of Bail Reform. We'll be joined by Ken W. Good, a member of the Board of Directors, Professional Bondsman of Texas. Mr. Good holds a Bachelor of Arts from Hardin-Simmons University, a Master of Education from Tarleton State University, part of the Texas A&M system. Mr. Good earned his JD from Texas Tech School of Law in 1989. He also was a member of the Texas Tech Law Review. Mr. Good has argued cases before the Supreme Court of Texas, the Texas Court of Criminal Appeals, and numerous courts of appeal, including the U.S. Fifth Circuit Court of Appeals in my hometown of New Orleans, Louisiana. He's the author of Goods on Bail, a practice guide created for the bail industry professionals, and he's written numerous articles on the subject of bail reform, including what successful bail reform looks like. Mr. Good is married and has 2 daughters. We'll talk with him about the failure of bail reform and zero bail policies, including the impact zero bail has had on domestic violence cases. Until then, have a safe 2 weeks. Good night.